So we already have around 29 participants, 27 already there. We're just going to wait for a couple of more minutes to other people who are going to join us. Oh, we have 60 attendees. And I can see a lot of IQ's existing clients there, predominantly what I'm going through. And we do see some of our partners, existing partners and potential partners joining us as well. Thank you, everyone, for taking time out on a Tuesday morning to join us for this session. I know it's the start of the work week and how busy you are, but as you know, there is an important policy update which has come through, and we want to, as in our endeavor to make sure the right information reaches our clients at the right time with the right information, we bring another IQ Startup Corners for you. As you all know, most of you who are here right now, we're nearly having 100 participants here. So I'm guessing we have existing clients, future clients, as well as some practitioners who are joining, because IQ has been doing startup visa since 2017. We have around 150 startups under our belt at this time. We pride ourselves to set up the gold standards in the industry when it comes to due diligence. And we have been working very closely with our immigration consultant partners, our immigration lawyer partners, to ensure that our clients are fully compliant with the startup visa program. We have continuously worked to keep ourselves abreast with the changes in policy, case law coming from federal court, with just one goal, that our clients, when they apply for letter of support, they have their due diligence packages are impeccable, and they clearly indicate how the applicant and their startup fulfills the requirement of the program. Last week, as you all know, when you're here, IRCC announced a substantive clarification to the startup visa work permit procedures. In fact, they have laid out significant changes to the evaluation criteria for the work permits under the startup visa. These changes for us, as I've talked to many practitioners, leading two of them are sitting on the panel today, they think it indicates a shift how the government will be evaluating work permits and perhaps a permanent residency application under the startup visa category. At IQ, we are happy about these substantive clarifications. Trust me, I am saying this after a very thoughtful process. We are happy about this clarification because these clarifications are no surprise to us, as they clearly lay out the intention of the program. In fact, at IQ Canada, we actually followed these unspoken rules for years because we knew what the program's intention was. We knew what the visa officers were looking for. It's a good news that they have now formalized these requirements, so others who were not fulfilling these requirements could now fulfill them as well, to make sure that the IRCC's intentions and the program requirements are fulfilled. So again, I said our endeavor has always been to get the right information to the practitioners, to the applicants, to the potential applicants, so they can make an informed decision if this program is right fit for you. So in that endeavor, this is another IQ Corner series. And today we are going to focus on this new policy, or the clarification which has come, how it changes the program, which things are changing. To help me with that, I have two very esteemed panelists with me. I'll introduce our first distinguished panelist, Elizabeth Long. Liz is a leading immigration lawyer in Canada. She's certified as a specialist by the Law Society in Citizenship and Immigration. She's one of the lawyers that I have had the opportunity to work and in fact learn from, and I'm amazed by how she balances the processing as well as appellate work together. Besides being her advocacy in the court and for her clients, she frequently presents advice on immigration issues to organizations, universities, members of parliament, unions, and the media. She has also testified several times before the Parliamentary Standing Committee on Citizenship and Immigration on various immigration policies. Our second very distinguished panelist is Mr. Phil Mooeny. Thank you, Phil, for joining us today. Phil is a regulated immigration consultant with over 22 years of experience in immigration industry, before that, he was in corporate career. I'm not asking anyone to guess his age right now. Let's focus on his credential and how amazing he is. Phil specializes in various business immigration cases. Beyond his building on his experience, over 2 decades of experience in the immigration industry, he's currently focusing on co-counseling with numerous authorized representatives with one goal to ensure every client gets the best representation. Phil, just like Liz, has been beyond advocacy for their client. Phil has been the past president of CAPIC. Those who don't know, CAPIC is the largest group dedicated to educating immigration consultants and advocating for concerns of immigrants and consultants to IRCC. He actually served as CAPIC president for 3 years. Before that, he was the CEO of the regulatory body ICCRC. Phil speaks to graduating students of Immigration Practitioner Program and presents before parliamentary committees to address pertinent issues. Looking at both of their credentials, how they're good at what they're doing, years of experience they bring, and their interaction with the policymakers, they were our first choice to bring them onto this panel to get you what you want to know about this policy change. So Phil, just before we started this, and Elizabeth, just before we started, we got bombarded with questions from our clients. So today what we're going to do is we're going to start with the questions that our clients have and what they are doing, and we will take it from there. Okay, can you please identify who has joined as 416-797-2467, please?
Hi, it's Pantea Jafari.
I'm sorry?
Pantea Jafari.
Okay, perfect. Okay, hi. So I think so Uros Pandya needs a regular link. She's on the panelist link. So please take care of that. Okay, so I'm going to start the first question that I have. I'm going to start with you, Phil. It's a major shift, as I have said, and I'm not going to reiterate myself on that. What has changed for the new applicant, Phil? And what are those changes? And what are those implications of those changes?
Thanks, Upasana. Listening to the long introduction and the long background for myself, I really wished I was younger. Okay, and then I'd have a much shorter intro. This is a bit of a difficult situation in terms of how to phrase our answers, because we have 2 very different groups here. Yep. We have clients of yours who are in the process of applying for the visa, and we have a lot of representatives who are representing other clients whose processes either haven't started yet or many who have. And amongst those many who have, a whole lot of the individuals and the representatives who are here were actually brought into the process late just to complete the permanent resident application. So we'll try to phrase the answers in terms of satisfying everybody's needs. First of all, as far as what's changed, nothing changed in this process, which basically was changing the rules after the fact. Okay, so anyone who filed an application under the previous rules, and there's very specific dates in here, anyone who filed in those steps, nothing has changed in terms of the rules. So, it's not like saying, you're winning 5-0 with a minute to go in the hockey game and the referee says low score wins. Okay, we've seen immigration do that in the past, but they didn't do it this time. Okay, so part of what's changed will apply to new applications that are going to be filed, but some of the other major applications, major impacts are in the interpretation of the rules for how to process a file after that it's been filed, and those will affect many of the people's applications in process. Okay, and it's a question of emphasis and interpretation. With regards to the new applicants to file, you need to understand there's some changes in terminology, and I would recommend every authorized representative out there to please go to the link to the operations manual, read through all of those items carefully, because I don't think we can combine, or we could list all of them specifically. But a couple of key points of emphasis will be to make sure that the application that you are working on to file for permanent residence, that you have made sure that the applicants meet the requirements for significant benefit. Okay. That wasn't in the program before. It's assumed that somebody coming in with an innovative new idea that's going to possibly change the world, that's a significant benefit by definition. But in these new instructions, the instructions refer specifically to the types of significant benefit that exist within the Canadian immigration system under the C10 application. Okay, and it's very important that we make sure that the applications apply to those specific requirements. Okay. Now, at the same time, there's a bit of a terminology. The designated organizations are now filing something called a letter of acceptance / certification or certificate. I forget the exact words. It's a one form that clearly identifies which individuals need to get a work permit because they're essential to the business. But in that form, the designated organization is asked to describe what is the significant benefit. They're asked to describe what the individual's financial obligations are. And some of those decisions and some of that information won't be available to you as the representative unless you ask for it. You can look at the letter of support and the certification document.
Certificate.
Yeah,
you mean?
But you won't see what the designated organization put in their application, because that application goes directly to IRCC. So you need to see it, because designated organizations are not immigration consultants or lawyers. They're not authorized representatives. And what they put in that document may not necessarily be in line with what has to be in a document that has those requirements. So make sure that you're looking at that document. The other thing that's there in terms of investment funds, it's now asking that not only does the individual have to meet LICO, the low income cutoff, for the next 12 months. Okay, they also have to show that they have investment funds, and they have to show the provenance of those funds. What does that mean? Well, it means that if they're putting in a business plan and the business is going to need $400,000 of funding in the first year, they want to know if that, where is that money coming from? Who has it, and where is it, and how did they get it? Provenance means that the money is clean. Okay. Well, for it to be clean, they need to know that if this was money earned by the individual's salary for the last 25 years, that's what you have to tell them. And that's the sort of level of proof you're going to have to provide. If it means you won a lottery, show proof that you won the lottery. If it means that the money came from various sources, but you never had to figure out where, well, it's going to take some work. So they're going to want to know where that money came from. Okay. The other one of the other significant changes that will apply to all new applications has to do with the fact that you can't apply for a work permit for any one of the individuals unless every other member, if it's a multiple application where there are up to 5 team members, all 5 team members must have filed for permanent residence before you can file an application for a work permit for anyone. Okay. And going forward with that, if you're dealing with an application for 5 individuals who are all essential to the business, you have to be aware that all of those 5 individuals will need to be in a management occupation, because they are all owners of the company. And they clearly state in the directions that you have to look at all of these individuals as being self-employed, all of them as owners and managers of the company. So if you think about it, if someone's coming into Canada and they put together a business plan that says, well, we're going to start with, in 2 years with 1 employee and in 3 years with 5 employees, and we're being very conservative. Well, when this file finally gets opened by an officer, okay, and you have 5 individuals named as being part of that operation, there better be 5 management jobs for all of those people. Okay. Otherwise, the essential people, if there's at least jobs for the essential people, you're okay. But if they're all 5 are essential and there aren't real jobs for them, everyone will be refused. Okay. So there are a lot of consideration. I encourage you to read through really carefully. There's a couple of other little points in that note that you might be interested in. They still have said that the work permit for an essential worker should not be issued for longer than 12 months, because it isn't expected that the application will take longer than 12 months to process. And people are saying, yeah, but it's taking 3 years. So, we've even heard almost recently that there were some applications for work permits that were issued for 2 years. Well, now they're stating clearly 1 year only. And you might be asking, well, how can they go from 3 years processing to 1 year, which is what the original program was? Well, this is linked to the levels program that was introduced in November that the government put forward. Last year, they accepted 500 individuals as permanent residents for the startup visa program. That's family members, dependents, and all the people involved. That's 500. The quota this year, or the level, is 3,500. And in 2 years, it's 8,500. To me, that signals that they are going to be devoting a lot of resources to processing a lot of these files. And it'd be great if they can get the processing down to 1 year. Okay. But that means every application that's in the system had better meet all of the requirements today. And everyone better be ready for a lot of procedural fairness letters or letters of request. Okay. And there are different questions we can. I'm sorry, I don't mean to answer all of the questions all at the start. That's just some of the emphasis for people who are starting, who are thinking about getting into an SUV application. They've been approached. Somebody says, "Hey, can you just do the PR application?"
Sure.
This is not simple. This is not your simple permanent resident application.
Yeah.
Okay.
No, thank you so much, Phil, for bringing this caveat up. We have over nearly 170 people with us on the webinar today. And as you said, it's a mix. We have mix of applicants and we have mix of practitioners. So what we are seeing is that we have a lot of Q&A coming in. So just in case we are not able to address all the Q&A, you are going to hear from us very soon, where we're going to have a separate session with Mr. Mooeny and Ms. Long for the practitioners, where it's going to be a different tone of telling how to process your application. And we will again have a follow-up webinar for the applicants per se to answer their questions. So please stay tuned for the next webinars that we're going to see, because we were expecting interest, but so many people coming together as a mix. We want to make sure that we just give you a general overview, but all of you have different niches, which we will have to come back on. Liz, I'm going to come to you right now. Phil gave an overarching view of what has changed. Am I right? And two buzzwords which I really hear and which we have been talking for years with our clients is investment in the startup visa. Years I have been here telling people, if you're coming for startup visa, you have to invest in the company. You have to run the operations of the company. And in fact, as the market was changing, this thing has considerably changed, because people were told, oh, just get the letter of support and the PR would come. So I'm just going to read a little bit what I am seeing in the clarification. And then I would like you to please explain about what is investment funds. And Phil has touched upon it, but more on the provenance too, because this is going to be a major impact on the applicants who are in the process or who are joining, what kind of documentation they should be expecting to provide to their practitioners or themselves if they're doing their application to send to the IRCC. Now, it says to assess whether the applicant is able to perform the work sought per paragraph R203A, applicants should demonstrate that their investment funds are available, transferable, and unencumbered. So my first question is going to be, what is transferable and unencumbered? You'll touch upon. The focus should be on the liquidity of the funds rather than on the amount. However, officers maintain discretion in assessing the funds required for investment. In addition, applicants should be able to provide proof of provenance of the funds that they indicate will be investing. So let's break it out into a couple of questions, Liz. First is, what is this investment fund? What is the sufficiency and where this is coming from?
Right. Just to build on what Phil has been talking about, the stated regulations that are passed by Parliament have not changed. What has changed is how IRCC says they are going to apply the rules and interpret these regulations. And this is really significant. What they are requiring with regard to investment funds and significant benefits, etc. These rules have significantly changed from before. In fact, what they have said is those who have submitted their work permits prior to May 18th, and they're still in process. The old rules were there, but the officers can now ask for more documents according to the new rules. So even if you've submitted your work permit already, under the old, before the changes came in this week. So I don't know what they want to do with the 5 days in between, what they said, but for those people who have already submitted the work permit applications, even if the old rules were there when we submitted the applications, the new rules will still apply to those applications, and officers may ask for additional documents. So it's very important to understand. And of course, people who are going to extend their work permits as well. That's also very important because these new rules will certainly apply to them. So the main thing, as you said, is the investment funds. Now, how much investment funds are people supposed to provide? Well, that goes back to the business plan. It goes back to what the designated entity had stated as to the financials for the business. So going back to the business plan, there should have been some sort of projected financials as to what it would cost for the company to operate. And as according to that, what the officers are saying is, look, if you want to come to Canada to work, well, then you have to show that you can actually do the work. And to actually do the work, you have to show that there are enough funds to run the company. Otherwise, how are you going to do the work, right? So what they are now requiring is that there are funds to do the work. As to how much each person has to provide, well, that's up to the agreement between the founders. If you have 4 founders and you've said 200,000 to run the business for 2 years, and you've each deposited 50,000 into the trust account, that's fantastic, right? Then we can show there's 200,000 ready to go. As soon as it's in an escrow account, it's in a trust account held by a corporate lawyer. As soon as they come, the funds will be transferred to the business account. Great, those funds are available, right? Now, that's not the whole story though, because we now also have to show the provenance of funds, especially for those applicants who are applying for the work permit. So where do the funds come from? What documents do we need to show as to where these documents come from? That can be very different depending on each person. If a person has, these are savings accumulated over time, and you can show that there are funds accumulated over time, that may or may not be enough. Again, this is very, very new rules that have, it's new interpretations that have come out. We don't at this point know exactly what documents IRCC officers are going to require for these kind of applications. What I would go by is what has been the case for other kinds of applications. So, and what would make common sense? So for example, if someone has sold their property and they have received their funds from the sale of a property, show that the property has been sold and show that these funds came right after the sale of the property. If someone received dividends from a company, show that the company has given them the dividends and that the funds came from the company. If someone has accumulated this over a long period of time, show that they have a salary that provides them with this amount of money, and show that you have, bank statements from not only 6 months, but a year or 2 years, right? And show that these funds have accumulated over time. So every person is different, but that does add another layer of requirement for applicants for work permits. And it was never even required for permanent residents as well. I think what we have to now turn our mind to, and I think this is what Phil was also talking about, is IRCC right now is really looking at how to evaluate these applications on a different kind of level than they were doing it before. Mm-hmm. Before, I think it was more of a reliance on the designated entities to evaluate and say that these applications are good applications. However, the designated entity their job isn't there to monitor and make sure things are done after they provide the support letter. And so now the officers are coming back and saying, well, the IRCC is saying to the officers, now your job is to make sure that whatever, is stated in the commitment certificates as to what they're going to be doing, that these people are actually doing this, right? This is common sense. It's what we have been telling our clients for many years as to, if you say you're going to do it, prove that you're going to do it and do it, right? But what we are seeing now is that IRCC is basically doing that, and they're checking now.
Sure. Thank you so much, Liz. This is very valuable insight. Phil, do you have anything to add on to the investment fund parts? Because I believe this is a significant change, especially from the practitioner's perspective, service provider's perspective. This is a very important shift. Like, now we have to show funds, we have to show provenance of funds, and is this fund reasonable enough to run the company? And that changes a bit. So if you have to add something on this.
Yeah, just a couple of points. What you can look at again is, as Elizabeth said, is other programs where this is a similar requirement. The one that's probably the closest would be the treaty investor work permit applications, where it used to be just under NAFTA. Now it's involving CETA and other places. With that program, you have to show that the funds that you are investing in Canada, were legally obtained. Okay. So it means, if you robbed a bank and tried to send money to Canada, it's going to be really hard to prove. But it does mean that you do have to prove something. The second part of it was you also had to show how the funds got to Canada to make sure that there was no inference of money laundering. Okay. So those are to me, that would be a key standard which you could defend. I see my Zoom picture freezes every once in a while. If my eyes are closed, I'm not really sleeping. Okay. I'm not that old. When with regards to the submitting that sort of information in line with these new instructions and absent any further clarification, you can defend that if the officers come back and say, I don't believe that these funds were, or you met the requirement of provenance. Well, that's the requirement of provenance in other immigration applications, and it should be acceptable, and you haven't explained anything else. So you might be on some pretty solid ground. There's the other example of how the QIIP program does provenance of funds, and that's a bit ridiculous. That says how, when you were 18, how much money did you have, and prove to us why you have more money now that you're 57, and tell us every step in between and prove it all. I don't believe that's the extent they want to go to. So to me, that would be the key element. But the other part, again, is to say, okay, you provided a business plan of some sort to the designated entity to show that here's the budget for the business in year 1, 2, and 3. They only want to know year 1, because again, they said they should be able to process all the files in 1 year. So if they only want to know year 1, figure out the total cost within that business. And these are separate from the LICO funds that you need to provide for your family while you're living here during that year. Okay, so this is additional funds that you need to show that you're going to meet those. And again, divide it up according to the shareholders of the business. All right, and make sure that everyone can do the same. And again, remember, if these are essential people, if there's 3 people and they're all essential and they all have to show the provenance of funds, if one of them doesn't do it properly, gets refused, everyone is refused. So this is really, really important to get right.
Perfect. Thank you so much, Phil. This is very important. And if you're an immigration practitioner and you're on the call, provenance of funds has a major evidence threshold for you that you will have to now manage with your clients. And I think so this particular topic itself would require a follow-up webinar from us. I would request you put your questions in the chat. If you're not able to address this today, please send it to us at info@iqcanada.ca, info@iqcanada.ca. We will bring these 2 guys back to make sure we answer all these kind of questions that practitioners would have within a week or so, or maybe in the second week of June once the CAPIC and the CBA conference is done. Okay, so on that note, I will go back to you, Elizabeth. Phil touched upon this and he's given the overview. So the 2 changes which I heard was investment fund, and second is these significant social cultural benefits. So as it is written in the legislation that now there will be a new administrative code for A77, thank God it will release some of the confusion which was happening because of C10 rejections, but it adds the question now, what is the threshold of these requirement of this significant social, cultural, economic benefits? I'll just read out here because as a legal training in the past, you read, you interpret. A77 is the code under which work of certain foreign nationals entering Canada to create a business prior to the finalization of their permanent resident application in the startup business class. I'll emphasize on the word may, M-A-Y, may create significant economic or social benefit. What has that changed? And Phil, I would ask you to answer later once he has done it, how it makes it different from C10, because it was mandatory. So what this may interpretation is, but Liz, what is this now? What is the significant social and cultural and economic benefits?
So again, these interpretation, it's quite different from before. Even though before, if you look at the instructions to the officers, it was supposed to be under C10 as to which is a significant benefit work permit. The instructions to the officers was never to consider whether or not there was significant benefit. In the previous instructions, there were never any sort of mention that there were supposed to be significant benefits demonstrated by in PR or work permits. What they are now doing is bringing significant benefit back, even though we're using a different code, even though it's no longer C10, it's A77. I think in these kind of situations, it's important to highlight various economic, social, cultural benefits. But I still don't think necessarily that an application should be denied because it doesn't rise to the level of a C10 significant benefit. The reason being is a C10 significant benefit work permit is there because a person does not qualify under any other category. They only and we are saying that, look, there is such a significant benefit for this person to come to work in Canada. You have to let this person come in. It's a very exceptional level. For A77, for startup visas, we have already had all of this different criteria as to how someone would qualify. It is a separate category on its own. Mm-hmm. However, I do think that because the requirement is there for a significant benefit, that it is something that needs to be spelled out. What it has to be is spelled out in the offer of employment. Mm-hmm. The offer of employment is filed by the applicant for every work permit that does not require LMIA, that is employer specific. So in these situations, on the offer of employment, the officer is saying that it needs to state what the significant benefit is. Mm-hmm. For the vast majority of applicants, you're going to come to Canada to create jobs. You're going to come to Canada for advancement of industry. It's going to be innovative. There will be significant benefits for each company. I don't necessarily think that is going to be a very difficult threshold to meet unless, and I think this is where the officer can have a reason to reject an application, is if the officer doesn't feel that this business is actually going to be successful and this business is actually going to be viable. This is where the officer can use the reasoning that I do not believe that this will be a significant benefit for Canada for the person to come on a work permit. And so it goes back to the viability of the business. And so that's, I think, why that is now in the application.
Phil, this is a very important topic, as you both were discussing just before we started that this has changed, this was not there. What's your take on this particular issue? Significant social and cultural benefits.
Well, I think it's very instructive that in the new instructions for officers, the last thing they refer to is how an officer has to write up a refusal letter. In recent court decisions, the officers have been overruled by judges saying, hey, you got these designated entities around there who are supposed to give you their opinion on whether or not this is a viable business. In other words, does it meet all of the requirements of the act? And you can't just come along and say, no, it doesn't, after they've said, yes, it does. So to me, what they're now telling officers is under, they want to avoid, and this is sort of get technical, but any sort of Vavilov influence by making sure the decision is reasonable. And they're basically telling officers to look at the significant benefit rules and follow those rules if you're going to refuse them, because you don't really believe this process or what's happening here. I think the other thing is it gives them a reason to refuse files which are not exactly in line with the intentions of that were stated by the designated entity when the letter of support was issued. Okay, and we know that what happens in these businesses, these are supposed to be innovative businesses that are globally scalable. So that people come along with the best idea, the good thoughts. They start the application, they start the business, they find out it's too tough. Yeah. It's much too hard. So they change the way, and at the same time, they're taking longer to process. In the past, when the program first came out, if you tried to make your idea work, but it didn't work in the first year, you still became a permanent resident. And they just said, well, thank you for trying. Your reward is a permanent residency. When the processing time stretched to 3 and 4 years, now all of a sudden people are having their businesses fail, but they know if they stop their business, they lose the permanent residency. So instead, they transition their business into something a little different, something that can make money. Okay, they can support the business expenses, or they do very little in the business, just holding it there. Well, now the officers have very clear reasons on how to refuse those applications. And we fear that there will be a lot of those. So to me, the whole C10 business, I think it's also had, I know I've had many client reps call me and say, can we flagpole? Can we take these people to the border, to do this because they're in Canada now? And we used to be able to do that. They're very clear now. There is you cannot apply for the work permits on entry. Okay, which is and I think again that's because we also know that the CBSA officers do not like significant benefit. They don't like it as C10. They don't like it as ICTs, under R205, and they don't like it now under the startup visa. So they're making sure that all of the C10 evaluations are coming to visa officers that are hopefully trained to look at this. But to me, that's a major problem. A lot of these innovative businesses are technical in nature. They're IT related, they're financial related, or they're basically marketing or complex marketing exercises which could succeed. And visa officers aren't trained for that. So sure. I would think that they've tried to clarify the reasons for refusal by putting in the emphasis on significant benefit. And all of us have to be aware of that so that we support and are ready to support each application, on the basis of its own merits. But again, it all has to be linked back to the exact requirements, because that also brings in now R89. And R89 is the rule that says, if you're coming to do a startup visa, that's what you have to do. If you do anything else as a way to help you get permanent residence while you're doing that, or if you change what you're doing just so you can get permanent residence, you're going to be refused. Okay. And that's really, again, important. And that's why it's so important that every representative and every client knows what's in that document that was sent in by the designated entity in order to confirm the letter of support. Okay. Everybody has to know what's in there, and you've got to stick with what's in there.
Got it. So, Phil, I'll come back to you on this another question. So we started with you asking what has changed for the new applicants. But if I look at the clarification, it clearly says, usually when something comes up, it is prospective going forward. But it looks like this policy changes are going to be retrospective, because it clearly says if the application was received prior to May 18, 2023, that is the day when these clarifications are coming, Officers should request any necessary documents not provided previously to do a complete assessment under these instructions. What does that mean? What has changed for the applicants in the system who are there now? Phil.
Well, I think some of the things we've already covered. The business about investment funds. Okay, then that's a reasonable request. The emphasis that the officer is going to look to make sure that each of the individuals is capable of performing the duties of the job. And they give them some pretty clear and more, let's say, advanced instructions on how to know that this individual isn't just hanging on to the application because, somebody wanted 5 people in the application and they've got an uncle who previously was, trying to come to Canada, and this is the only way they can come, but doesn't really know anything about the business and doesn't understand it. All of these things are now going to be looked at in light of the new requirements that they're emphasizing to the officer. Make sure under R200 that you meet all of the requirements of the Act. And again, by referring to R200 and R205, these are regulations. That means the officers are on solid ground when they go to refuse. We've seen let's call it a very high percentage of refusals of SUV visas end up in federal court.
Yeah.
Now, by and large, almost all of them are settled in the government's favor. But it's a long and expensive process. And we believe that, and I believe anyway, that a lot of these changes are meant to take a look at how applicants got into the system to begin with through the peer review process. But even then, how are these applications going to be refused under the Act? Not because an officer felt, I just don't like this. Okay. And I'm just going to give a reason, which in the past might have been good enough, but ended up in federal court. Okay. So now, that's one of the significant things that's happening here. I think for people in the system, and these would go to the clients who are on the program, and they certainly won't apply to your clients because we know you do a good job looking after these folks. But if people have clients in the system and they start getting procedural fairness letters and requests, they need to make sure that the designated entity who is helping them or help them get started helps their authorized representative in completing these applications. And maybe I'll address that later when we get to question number 3.
Got it. So just on this note, and I would ask Liz to step in after I make this statement, is I know that a lot of our past applicants are there on the call today. And we asked them to join because we wanted to make sure they understand what the policy changes are. But I also want to reiterate this thing. This is not news to IQ Canada. As you all know, who've been working with us, we made it mandatory for you to invest money in the company. Trust me, we have lost a lot of clients in the past when we said you need to invest and they said no. We are the only one asking for this, but we kept our ground. So you all are pretty safe because none of you have come on a file where you have not committed to invest. Only thing that changes for us is now we will need to, your funds are mostly in Canada in trust accounts as well. So we were already way ahead. We knew it's a business immigration program. If we are not going to run the business and we are not going to invest, we are not fulfilling the requirements of the program. What we will be requiring from you is now just to show where those funds were coming from, which we can very easily attain if it's retrospectively applied for. Secondly, significant benefits to Canada. We always worked with the right practitioners who told us what the program is all about. We made sure every application which went from IQ benefits to Canada were always there, even if they were not mandatory, because we worked hard to show the value you and your business is bringing. So you're not in a trouble here. It's what changes have. We need some documentation, but everything what is required by the law is still in your file. Liz, anything to add here? Because you have had the opportunity in the past to work with several of our clients. You have seen what we do.
Yes, I think we're in pretty good position. The new requirements, they are saying things like we need to show that the person will be performing duties that conform to the significant benefits, that they have the background, the education, the IELTS, the all of that has always been part of our application package. I think the only thing that we really do need to show now is the provenance of funds for investment fund. And we'll be certainly working with each client to look at what these will be.
Perfect. Thank you. Phil, I'm coming back to you, and this is very important now. So the clarification has come for work permits. Am I right? Predominantly. We are seeing that it might impact the other PR applications. So it looks like this is all about essential application, the clarification coming now, essential applicant withdrawing, essential applicant getting refused. Who should be deemed essential, though it is with the designated entity, but who should be deemed essential? And do you think, it's a follow-up question, I can remind you because it's going to be a long answer, any changes for those who are not essential?
Sure. Well, this is one of those where common sense prevails. An essential worker is clearly someone who's needed to have the business be a success. Okay. And that just means if you're going to start up a company, you clearly need a senior manager. All right. Yeah. Unless you have a Canadian partner who is a senior manager and they're looking for someone who's coming in to take an ownership position, or a group coming in to take a majority ownership position, who provide technical expertise, who provide financial expertise, who provide management expertise. Okay, those are the people that, any sort of company that's going to have 1, 2, 3, 4, or 5 senior managers down the road needs to have employees, needs to have a business operating. And within any of those, it's not too hard to identify which people are essential. Okay. And it isn't a question of not essential because, they happen to be my brother. They're essential because they have a function to perform that company must have. Every company needs that gets to be any size needs a senior manager, needs a financial manager, needs a technical manager if you're in the IT field. All of these people need that sort of support. So it's not too hard to see who is an essential person. Okay. The problem will come in with non-essential people, because with processing times that take 3 years, if you have a group of 3, 4, or 5, and only 1 or 2 are deemed to be essential, well, that means they're coming in. We know they're going to have to get the business started. We know they're going to have to put money in the business, everybody. We know that the business is going to have to go along a business plan. Well, if you're going to operate for 3 years and none of the other people are working in the business, how are they required? And again, this is where R89 will come in. This is where the visa officer are going to come along and say, well, you know what? Your business seems to be doing great, but Frank here, who you deemed as to be essential because he's going to be the HR manager, you've already got 12 people working there. Who did that job? He's not essential. You're being a success. In fact, in this case, the more successful you are, the harder it will be to justify that the other people aren't just hangers on hoping to get PR. And if that's the case, I would expect them to be refused. And we're seeing that already, because now that we're seeing procedural fairness letters, and they're asking for things like a succession plan for those individuals who didn't come to Canada to start the business and are waiting for permanent residence. What are they going to be doing after permanent residence? Now, between everybody, it doesn't matter. Once you become a permanent resident, they're not going to do anything to you. Unless you have fraud in your application, you're a permanent resident. And it's like any other business immigration program or any other program. Once you're a permanent resident, all the rules change. They can't just get rid of you. But until you're a permanent resident, you can absolutely expect they're going to challenge every single one of those people that is not already in Canada working at first, and especially for 3 years. It's one thing to say, I'm going to come in to start up the business, and in 6 months, I'll have my first 3 people hired and I'll have a facility there. So by month 12, when I'm getting my PR, I will have to have my production manager here, because now I'll have the machinery and everything else. I need him there. So he doesn't have to get a work permit right away, but he will need his permanent residence to come in and support the business. That's the way the program is supposed to work. But when it gets out to 3 and 4 years, those are the people who I believe are extremely vulnerable and could be refused. Okay. And the problem is if they think that's going to happen, and let's say you've got 5 people and they each own 12% of the business, so they qualify as 60%. If one of those people pulls out before the final assessment, now the group doesn't control 50% of the company and everyone gets refused.
Got it. Got it. This is very valuable. Thank you. Liz, who's essential and what it impacts the non-essentials right now?
So, I think IRCC themselves, when they first came up with the non-essential versus essential, I don't necessarily know that they had in mind what they really wanted to have happen, because non-essential applicants can also get permanent residence. So what is the difference between non-essential and essential? The essential applicants can apply for work permits. And if one of those essential applicants gets rejected, everyone goes down with the ship. Non-essential, you can't apply. And if you get rejected, you still don't bring everyone else down. But does that mean that, everyone needs, I think it's basically in the end, how I would think about it is this. What's been made abundantly clear is that evaluations on the essential nature of the applicant is going to be done now at the work permit stage. Now that translates, I think, into the fact that work permits are also going to be very important to prove the essential nature of a person as well, as Phil has said. Does that mean that an applicant who is essential and does not apply for the work permit will be rejected? In the past, no. We have had many of the essential applicants get permanent residence, even if they haven't yet applied for the work permit and have come to Canada, because it can be argued that people can work remotely. And they have, if I'm a finance, manager, I can certainly do a lot of work remotely. If I'm an IT manager, I can certainly do a lot of work remotely. I don't necessarily know that that is going to be necessarily changed for permanent residence. However, I would be wary of just relying on the past. Our advice has always been that if you're an essential applicant, that you should try to come to Canada to try to run the business. If it is needed, that you should run the business. And I would emphasize that again for clients, that if you are an essential applicant, and it has been stated on the support letter of support, it's been stated on the commitment certificate that you would be needed to come to Canada to run the business, and do so. Don't wait until you get permanent residence, because it's a chicken and the egg situation. An officer, if you say that you're going to be needed to run the business, and the officer says, well, you haven't been running the business, and you say, well, I don't want to run the business until I get the permanent residence, the officer is not going to be okay with that. Right?
Yeah, if I could add one thing there, Oksana, some of the language in this advisory also speaks to that, where they first of all, they've now made it clear you should only apply for work. You have to apply for work permit as an essential person within the same period that you have to apply for permanent residence. Okay, and you must apply for permanent residence first, then you apply for the work permit, but you get 6 months. If you apply for permanent residence and you apply for your work permit, that work permit will be issued for no longer than 1 year, which means you should be coming to Canada within that 1 year to accept your work permit, and to because you have 12 months to even come to Canada to get your work permit, but you need to come to Canada to get your work permit within that time frame. That's now, let's say that's even the longest could be 1.5 years. All right. If none of those happens, you better be ready to explain why you're an essential worker and you didn't come to Canada. Now, working remotely might be a very good reason, but I wouldn't trust the fact that some of these officers are not going to say, I don't believe this. To me, the best advice is, if you're deemed essential, apply for the work permit. If you get the work permit, come to Canada, get your work permit, then worry about renewal later. Whether you need to be in Canada that whole time, nobody says you have to be in Canada 24/7, 365 days a year. You can go back and forth to your home country. You can do work remotely, as long as you're actively engaged in the business that you have because you're essential and you can show you're actively engaged in the business, then worry about work permit renewals.
Yeah.
What you shouldn't be doing, in my opinion, now is be deemed essential and not apply for a work permit. That's going to raise too many questions.
Yeah, and I think so. I heard the same from you, Liz. If you're essential, apply for work permit. If you are essential and you're not applying for work permit, that's going to be a major red flag. Okay, I have another question for both of you, and I can see there's several questions in the chat. I would apologize if I cannot take all the questions. I promise we'll have to bring them back because all the questions which are on the chat are very important and very reasonable, but we had some questions before which we need to touch upon today. So please send your questions to info@iqcanada.ca. We will make sure that we have a follow-up webinar with Phil and Liz to make sure those questions are answered, and we might have one for the practitioners and one for the clients. Phil and Liz, I've been reiterating this thing for many years, and I've been confronted many times when I said letter of support does not guarantee you PR. You need to invest. I was told, oh, others are saying letter of support, my PR is done. I'm going home and I'm going to land Canada on PR. Letter of support qualifies you for PR. I always said, you have to run the business. Again, the designated entity, it's their job and your job to make sure everything gets to the IRCC, that why you qualify for startup visa. And Phil, you said a couple of times that now you need to know what the designated entity is saying in commitment certificate. It aligns with what you are saying because that is the message which has to go. So we know that it is not just what you submit to the designated entity, it's still the onus is on you. And if you're working with the practitioner, along with your practitioner, the onus is there to show to the government why you were given the letter of support and why you qualify for startup visa. So myth around that LOR guarantees PR has been totally trashed. When we read this, the designated entity must assess the potential for success of the startup visa business opportunity against their own program requirements. While this assessment may form part of the officer's decision, it is the processing officer who must complete the assessment under paragraph R205 sub A and be satisfied that all requirements of section R200 are met. So I have two follow-up questions for you. This means there is a lot of discretion and power with the officer to assess the business. My second follow-up question is, I'm hearing that at the work permit stage now. So even at the TRV, when you're applying for a work permit, this means they are assessing the validity. How does it change things for you, Phil?
Well, to be honest, it doesn't really change things because we knew we have to do all these things anyway.
Yeah.
And as practitioners, we know that we have to make the best efforts. And if there is a refusal or a challenge to that, it's because an officer has made a mistake in law. Mm-hmm. Then we have the courts as a backup. So the idea, first of all, is to make sure we meet all of the requirements. And I think part of this and part of what you're describing has a lot to do with the history of the program. And okay, you're dealing with an old guy here. So, for me, all the history was current events, right? But you have to understand how this program first came into being. Mm-hmm. There's two reasons why this program came into being. One was that the federal government had abandoned business immigration. They had canceled the federal investor program. They had canceled the federal entrepreneur program, and they learned some lessons from those, but they still politically had to have something to tell people. And I remember some of the press releases when they canceled these programs, which were bringing in 5,000 to 10,000 people a year. They came out with saying, we've got the startup visa. Here's our new approach. We want to bring in innovators. We want to bring in people that are going to be the next Steve Jobs, ignoring the fact that Steve Jobs would have been refused entry because he, was a drug user. And all of that. So that's what the program started. And the second one was because the minister at the time went down to Silicon Valley and saw what was happening in the startup industry and thought, what a great way to bring, somebody into Canada who can create 50,000 jobs, So they threw this program together. They put it out as a pilot project. They told us on January 1, we have 500 applications. By February 28th, that's the quota. By February 28th, they hadn't received a single one. The program then limped along for the next 5 years and admitted as many, I think 75 people into Canada in 5 years. And typically when we expected this program to be fully canceled, they made it permanent. Okay. So don't ask me to explain why, except for political reasons. Now, the good news is that some designated organizations, which were very good at incubating and helping Canadians set up incubator businesses, got involved and started doing things right by really helping people get started. And we had some successes early on. The problem was that the requirements for the program were very simple. You need a letter of support. Well, if it was easy to get the letter of support, which in some cases turned out to be, that was easy. You needed to file an application for permanent residence. Okay. And that's basically all you had. And you had to prove LICO, which is for business people is insanely simple. So you had to do those three things. And boy, you got permanent resident and you got it within a year and you didn't even have to start your business. Well, of course, that was like, catnip to a cat. Along came everybody who couldn't qualify for any other program and they had a multiple. You could do this for 5 people at once, not just one. Okay. And we've seen this before. And you have a massive number of passive investors out there who just want to pay money to come to Canada, and a large group of unethical practitioners of any kind, including agents in other countries who said, I can sell this. I used to sell the Quebec immigration program or the federal immigration program and make hundreds of thousands of dollars. Now I can sell this one. And you had designated organizations like some venture capitalists, some designated entities who participated willingly in this, in promoting this program for volume. And so now you ended up with a program where the demand greatly exceeded the supply, and then COVID hit, and the demand kept going, and IRCZ couldn't even address the issue until now. And it was only lately when people started to worry about a moratorium on the program, which for designated entities would have been fatal. You can't have your whole organization structured for this, that they finally came out and said, no, we're going to come out with new instructions. All right. And that's what's motivated them to come out now. But basically now what they're coming out and saying is we didn't control intake properly. We didn't set the standards for intake properly. Now we're going to get everybody after they've applied. And it's going to be a pretty difficult time going forward. And that's my history lesson for today.
Oh, that's very important. Liz, your take on this. How does it change the things?
Yeah, no, I agree with Phil. I remember when they came out first with the startup visa, nobody thought it would work. Everybody thought, and it didn't work for so many years. I think what made it work was designated organizations caught on to, we can actually raise some money by doing this. And that's when people realized that there was money in this, that's when it shot up. It's absolutely true that I've heard many agents come to me and use it as a passive investment, and they've been selling it as passive investment. And that's why I don't work with them, because this absolutely cannot be passive investment. It's not allowed in the regulations for it to be passive investment. And what the government is now trying to do is finally they're trying to evaluate it so that it's not passive investment. They're trying to figure out, how do we make it so that people actually need to demonstrate that they're going to be doing this. And they want to do it more at the early stages. If you do it in the 2-3 years stage, people have already signed on to it. They've committed to it for 2-3 years. If they do it at the work permit stage at the very beginning, what they are saying is, well, you know what? You haven't demonstrated. We're going to refuse you. And if you get your work permit rejected in that stage, it is going to be very telling for the PR. It's not necessarily for sure that your permanent residence will be rejected, but what the reasons are for rejection by the work permit officer is going to inform what the reasons for permanent residence will be. So that work permit application now becomes very centralized to the success of the entire permanent residence application. That is why choosing essential applicants is going to be very, very important for later on for the entire application.
Great. I think so. We are touching that 1.1 hour, 5 hours mark, and I have so many questions. We will need to have a follow-up on that. Please send our questions. There is one question I'm going to address. We're asking, what is IQ? I just want to clarify, IQ is not a law firm. We are a business consulting firm. As many businesses, when they're planning to move to Canada, they're amazing startups in their home country, but North America is totally a different beast. And immigration lawyers are really, and immigration consultants are really experts in what they do. But sometimes it is difficult for them to fathom how to help their client to do market research, how to make sure they know about the competition, whether the product is a right market fit for the Canadian market. So those aspects of the application, which are beyond immigration at this time, that is where we come and help our immigration practitioner partners, clients, to help them understand what is the Canadian market, what it looks like, what is the competition analysis is looking like. And then we help them to put all that information in a business plan and a pitch deck, which they can take to the designated entity to present. And we come on board that we have helped them to do that because that's what we need. And people have been doing for ICT, intra-company transfer. You've been hiring companies to get the business plans done. That is what we do. That is where we stand for. We make sure that these clients, they get every other services that they're looking for. If they need a corporate lawyer, we help them engage a corporate lawyer. They need an employment lawyer, we help them retain an employment lawyer. If they need an IP lawyer, we go and help them find an IP lawyer. If they need an accounting services, we help them with the accounting services. If they need some help in Canada with the financial modeling, we can help them with the right financial consultants who can figure out, is this business is accessible? We are a service provider integrator who provides services. We are not a law firm. And in any business immigration, there is nothing that we are doing is beyond our scope. We are bringing the market detailed services, helping them with pitch deck, business plan, pitch coaching to get them through the process. We are not a law firm. We don't offer legal services. We help them make connection with the law firms so that they can get their work done. So if you have any confusions, you can please call me up and we can definitely let you know who we are and what do we do. Okay. On that note, again, last words, Phil. On this, we will have to have a follow-up session. There are so many questions which I couldn't address to because I think so maybe it needs 3-hour session next. But your last words, and please, we will bring Phil Mooeny and Elizabeth Long to answer all your questions. Send your questions to at info@iqcanada.ca.
Well, first of all, don't want to sell yourself short, Prasanna. I know that you are not a law firm, but you are a lawyer, and you have the ethical principles and follow those same principles as all of us authorized representatives have to do. To me, I just need to send a message out to individuals who had prepared the permanent resident files for the for applicants for the startup visa program who weren't necessarily involved on bringing them to a designated organization. Okay, for those individuals, what you're going to find out is that you're alone in this. When this application goes into IRCC, and even though that's all you were paid to do, when the letters of inquiry come out, when the procedural fairness letters come out, when refusal letters come out, your name's on the file, not the designated entity. And already I just talked to a rep yesterday who had a letter of information request from IRCC about a file. They went back to the designated organization and the organization said, hey, we did our job. We got you the letter of support. And clients out there who get a refusal are going to say, it's your fault. Okay. So you need to be invested in this business far greater than you might have thought when you thought you were just preparing really a simple permanent resident application like you've done for so many others. You need to go back and take ownership of everything from the start. And a couple of points that you might want to consider. If what we've told you and with what you're reading and the new instructions, if you decide that these applications, they're going to fail, all right, you need to work out a plan B now. While the individuals are in Canada working, if they have a company and they're working, their work permits will state that they must work for that company and they must do the job duties that are required by that company, but it doesn't mean they have to keep the startup business. If you know their application is going to fail, have them use that work permit to start a different business and look at a different business immigration program if you can. You know, at least you can suggest these things to them, all right, if you know they're going to fail. Because I can guarantee you that what's going to happen is when the refusal letters come out, and if they go to a designated entity, the designated entity, and we've seen this in other cases, are going to say, This is terrible. We said it's a good business. How dare they say it's not a good business? We want you to go, you should go to federal court. And there will be lawyers who will be happy to take the business to federal court. And so far, I believe 100% of those kinds of applications have failed. But it's going to take another 2 years while these people who put in all of this money are now into year 4 or 5. Their kids are in school. You know, they've got their families here. They're becoming, and they've got a dream to become Canadians. And for me, all of us as authorized practitioners, we have this awesome responsibility that we are involved in helping people change their lives and helping Canada build a country that everyone can be proud of. And we have to do everything in our power to make sure that these individuals are not tainted because the program was poorly designed to start with, because what they were sold was not what ultimately ends up being the deciding factors. We have to help them achieve their dreams. And they only came to the program, to be honest with you, because they want permanent residence. Nobody would go through all of this trouble just to start a business in Canada when they could do it in their own country. They all want to be permanent residents. So in order to stay true to our vocation, if you will, and yes, we all have a vocation. It's not just a job. In order to stay true to that vocation, we have to make sure that we do everything we can to help them achieve and their families achieve their dream of coming to Canada. Okay, so that's my last word on the subject.
This is very valuable. Thank you, Phil, for putting that out very loud and clearly. Liz, your last words on this.
So this is for the applicants who are here as well. I have to say, you know, if you've been working with IQ, I don't want you to lose sleep over this. That being said, please listen to us when we say you have to come and work on your business. We're not magicians. We can't force you to do things. But we can only advise you on what we think that the officers are looking for permanent residents. So when we say you need to be working on your business, it's not just because, you know, we want to see you in Canada and we think it's fun. It's because we're serious. We're giving you advice to put your best foot forward and be in the best position for your applications to be a success. Okay. All right.
Thank you so much, both of you. I know I called you up on a Saturday morning saying this is a policy update and I need you to be on the webinar. Thank you so much for taking our request and be here in less than 48 hours, going through the legislation, not the legislation, I should correct, going through the policy clarification with me, answering my question in the last 48 hours. This is very important so that people understand how the program is going to be interpreted by the visa officers going forward. On that note, people whose answers we haven't answered, again, I'm repeating, we will have a follow-up webinar with Phil and Elizabeth, and we'll make sure that we answer your questions going forward. IQ Canada and our team would be at the CBA conference, immigration conference in Ottawa on 2nd and 3rd of June. If you are there, please come and see us. We'll be more than happy to answer who we are, what do we do, and how we do it legally and ethically. Then also we are going to be there at the CAPIC conference in Winnipeg, which is happening on 8th and 9th of June. Please come and see us. We want to help you and your clients to make sure their startup visa application is a success. We are a business expert team supporting your applications. Thank you so much, everyone, for your time. There are questions regarding will the recording would be? Yes, we'll put the recording on our social media handles. We will also what we do, because there is so much information, these two experts who have come up and shared their valuable time with us, is we will put each question separately also in the shorter videos if you want to hear. As I told you, Phil is an expert in his field right now. And what he's doing is, if you're new to the immigration practice, you need someone to guide you. He's offering his co-counseling services. Please reach out to him. If you need his contact information, we can provide. Liz has been practicing immigration law for, I think so your law firm just celebrated their 10 years anniversary last year, am I right?
15 years.
Yeah. So these are people who have handled all kind of files. If you have any questions, we are more than happy to take you them to get the answers for your question. Thank you so much. And we look forward to many more sessions. Thank you again. Have a very, very good rest of the day.
Thanks, everybody. Bye now.
Bye.
Thank you. Bye.